Good morning and good afternoon, everyone. I'm Jamie Parrott, Vice President and Chief Operating Officer at MedResults Network. And as always, I'm delighted to welcome you to our fifth educational webinar presentation of 2019. And as you can hear, I'm a bit hoarse today, so I'll keep my comments to a minimum, but I want to remind everyone that today marks the first presentation in our series of risk management and business protection webinars. And like any industry, the aesthetic medical space can be fairly litigious, meaning medical providers at every level need not only to be well trained and follow proper protocol, but they must consider the protection of themselves, their business, and of course, their wealth or assets. Today, the number of medical malpractice suits filed each year in the U.S. tends to vary, but the overall trend is that they're on the rise. And I think the statistics shows that the average annual number of suits filed each year is about 85,000, with the actual number of medical injuries estimated to be about 1 million per year. And this is not just aesthetic medicine. It's sort of all-encompassing in the medical space, but the fact is that this trend is on the rise, and it should be an important statistic for everyone on the line. While many individuals believe that asset protection, insurance, or strategic financial planning are primarily for business owners or medical directors, the truth is that everyone should have a sound knowledge of how to become financially stable, how to prepare for your future, and have an understanding of how to protect the wealth that you will or have already accumulated with little risk to you. And in a position where patients are coming to see you for treatments or procedures that are typically low risk, the fact is that an adverse event or reaction could occur, which of course we hope it never does, but we want to ensure that you as a provider are protected. So while today is not about medical malpractice, we are going to discuss the topic of understanding asset protection. And we've invited special guest Douglas Lodmell, the co-founder and managing partner of Lodmell and Lodmell, a leading asset protection law firm, here with us today. Doug has led Lodmell and Lodmell since 1997, and he's a leader in the asset protection community. He's a creator of the breakthrough concept of the Bridge Trust, and he's a published author of many articles and the book, The Lawsuit Lottery, The Hijacking of Justice in America. Douglas spends much of his time teaching, speaking, and leading thousands of business owners, corporate executives, investors, and other professionals who have often worked most of their lives to accumulate wealth of various types, including real estate and securities. And he continues to help thousands of clients protect their assets for the future. So we're delighted to have him here today. And we thought that Doug would be the best advisor to give you information on how to protect your assets or better your current situation, and of course, to protect your future in the long term. So before I begin, I want to let you all know that while we do not have a live Q&A at the end of the presentation, we do encourage you to ask questions of Doug, and we'll get to them at the close of the webinar. And if you have a question that you want answered live, please type your question in the live chat box. Or if you prefer to ask a question privately, you may do so in our short survey, which will pop up automatically after the presentation closes. And keep in mind that if you've set your pop-up blocker on, you may not have access to view the survey. So for those of you that do have questions and have this mechanism in effect, you can always email me directly, and I'll be sure to link you to our presenter. If you can take the time to fill out that survey, it really does provide valuable feedback for us and our partners, and it's the easiest way for us to get your questions. So without further ado, I would like to introduce Douglas Lodmell of Lodmell and Lodmell.
Thank you, Jamie. I'm happy to be here and talk about this subject of asset protection. And you're right, it's funny, you were talking about even low risk and minor procedures being an issue. They really are. And sometimes, ironically, those are the issues that get people in trouble, is the low risk ones. And I've got several real stories from real clients where that was exactly the case. Today, what we want to accomplish is to really understand what is asset protection. It's not completely understood. It's not automatically understood by people. And there's a lot of confusion about what really makes asset protection up. Some people think it's just insurance. Some people think it's hiding your assets, like some type of James Bond Swiss account. And in reality, it's not either of those things. What asset protection is creating a legal barrier between your assets and a potential creditor. And that potential creditor could be an actual creditor, it could be a bank, it could be a patient who ends up with a lawsuit against you. For many of us, the biggest risk is actually employees. So it could be an employee. where you didn't get something right or they perceived that you didn't get something right. In any of those cases, it doesn't take a wrong action to cause liability. It just takes a bad outcome. And unfortunately, like you mentioned, there's lots of ways in which you do nothing wrong, but the patient or the client or the employee still perceives a bad outcome. And fortunately or unfortunately for us, and fortunately for them, there's plenty of lawyers out there that are happy to jump in and go, oh, bad outcome, let's see who we can sue. And that's what we're all about, is protecting you from those types of issues and lawyers. So is asset protection necessary in the United States? Well, there's over 40 million lawsuits filed every year. If you're in any big city, most of the outdoor billboard advertising is attorneys. I was recently in Las Vegas and I counted, and it was 8 out of 10 billboards were attorneys. The other 2 were for the hockey team. And so you can see the focus is very much on trying to find new fodder for the machine of the lawsuit industry. Claims by employees are now probably a bigger risk than claims by patients in many cases. So if you have 10 employees and you see, 1,000 patients a year, those 10 employees make up at least as big a risk as your patients, if not a bigger risk. Legal fees and awards and the entire cost of litigation in the United States is estimated to be in excess of $300 billion a year annually. That's a massive amount of money. It's bigger than most of the top 10 Fortune 500 companies put together. It's a huge industry. And insurance, which I love, and I absolutely encourage everyone in listening to this webinar to have, unfortunately, it's just not enough. And insurance companies I am dealing with constantly, when their first course of action is to look at the risk, look at the liability, and then say, do we fight this? Because that's one of the tools in their toolkit, is just to deny coverage. Whether they have a legitimate right to deny coverage or not, that's a different issue. Do they deny coverage all the time? They do. So insurance is important, but it is not sufficient. Necessary, but not sufficient. So what are the goals? What are we trying to achieve with asset protection? Well, one, effectiveness. It's got to be effective. You can't have a plan that looks like it works but doesn't work. So number one, it's got to be effective. Number two, control. I know my clients, and I've been doing this for over 20 years, have thousands of clients. They all want control of their assets. So it's not about just giving them away. And while that may be something you hear, it's not a good strategy. Costs. Keeping the cost reasonable, both to set it up and to maintain a plan, is very important. And then compliance. One, keeping your plan in compliance, but two, keeping the cost of that compliance minimized. So, not a lot of extra tax returns and reporting requirements and maintenance requirements and annual state fee requirements. In other words, keeping it as simple as we can, but not simpler. So just enough. So what are the tools available to you today? Well, we're going to talk about 3 of the major tools. These are the limited liability company, which many of you are probably familiar with, the asset management limited partnership, which is probably less familiar to most of you, and then the asset protection trust, which is probably the least familiar, but likely the most important when it comes to actually protecting your assets. So the limited liability company. This is a very standard tool nowadays. Most people have heard of it, and I would guess that a good percentage of you listening actually have one of these in place already, whether it's for your company that you're actually operating your business through, or whether it's for an asset that you have, like a rental home or a building, your office building. The limited liability company is a great tool to wrap up and protect those type of assets, which we often term as risky assets. So if you have an office building, people can come into it, they can slip, they can fall, it can burn down, there can be accidents. So we term those type of assets risky. An airplane is risky, a boat is risky, even a car, actually, especially a car. So what LLCs are good for is they segregate those assets and they keep them into separate baskets. So if you have an office building worth $500,000, but you also have an airplane worth $200,000, you wouldn't put them in the same LLC, you would segregate them. It has something called charging order protection. What that means is that if a liability is issued against you and you're the member of the LLC, the LLC is not automatically responsible to pay your liability. Instead, the holder of that liability can get a charge against your membership interest in the LLC. So it's not that there's no remedy, but it's that the remedy is limited, and that puts you in a better position because you have more leverage and you can negotiate and more effectively when someone can't just come in and grab your assets. The second tool is called an asset management limited partnership. It's very similar because charging order protection is also its primary source of protection, but it does things a little differently. In our case, we like to use this as your holding company. So, and at the end of this, you don't have to write anything down. We're going to actually show a diagram of how it fits together. So for the visual learners out there, we will put it together visually. But it is a holding company and it can hold the interest in those LLCs. So you can think of it as the umbrella company that holds other companies. It has very strong charging order protection because we use a state where that charging order protection has been proven. And we like Arizona for that reason. It's also very easy to maintain in Arizona and very low cost, as in there is no cost and there's no annual filing. And that keeps it easy to maintain, and that's what we want. You can include family members. It's a great estate planning tool. And most importantly, it is the ideal structure to marry with the asset protection trust. And if privacy is important, it can be set up in such a way that it creates a privacy shield around your assets as well. The third tool, and really the one we'll spend the most time on today because it's the least well understood, is called the asset protection trust. Asset protection trusts are special types of trusts that may or may not be able to move your assets out of completely the US court system altogether. And we'll talk about why that's important. It greatly enhances the domestic structures we just talked about of the LLC and the limited partnership. It's not limited to any specific risk. So it's not like insurance where you have to define the risk. It is protecting all of your assets, regardless of the risk. It also can be used for privacy and clearly has a high degree of protection. So let's look at what an asset protection trust actually is. What it is a self-settled spendthrift trust. That's the legal term. Self-settled means that you are creating it for yourself, and spendthrift means it is protected from creditors. Spendthrift is the legal term that defines what restrictions are around the trust and the distribution, and those restrictions are always pointed at creditors. So the self-settled spendthrift trust is the definition of what an asset protection trust is. There's two schools of thought about how and where to create these. One is internationally, and the other is domestically. We're going to talk about the pros and cons of both because this is very important to understand because they both have advantages and disadvantages. So we start with the international. It was created first. It was created in 1984 by statute in a faraway country called the Cook Islands. That was the first jurisdiction. And the foundation of that statute, which is the Cook Islands Trust Act of 1984, is that the Cook Islands is statutorily prohibited from recognizing a jurisdiction, a court order, or a judicial proceeding from any other jurisdiction in the world, which is very powerful. So if you want to try to get into and break into the assets of a Cook Islands trust, you can't take your winning lottery ticket in the form of a judgment from a US court and come down there and have it mean anything. It means nothing. You have to start your case over from scratch. You have to prove your case to the highest possible standard, which is beyond a reasonable doubt. And for the people who follow any court TV or the OJ trial, you know that proving a case beyond a reasonable doubt is exceedingly difficult. It is the murder standard. It is the highest possible standard. You are not going to be able to get a free attorney down in the Cook Islands because they do not allow contingent fees. So you're going to have to come down there with a big checkbook and write a big check to get an attorney to take a case. Once you file your claim, you can't amend it. You can't go fishing. So it completely removes the option of what we call here fishing expeditions, where you sue somebody, you're not really sure what you're suing them for, but you'll figure out something to sue them for once you get into the discovery process. That's not possible in the Cook Islands. And if you do lose, which is very, very likely if you're a plaintiff trying to prove a case beyond a reasonable doubt with all of these hurdles, then you're going to pay the legal fees and the costs of the winner. So there's a real financial risk for you to try to attempt to break into an international Cook Islands trust. And finally, probably by the time you figure out that this is what you want to do, you're prohibited from even filing a claim because the statute of limitations is very short. So the advantages of this are now proven. We have more than 30 years of history of international asset protection trusts, particularly those out of the Cook Islands, and we can say very unequivocally that they are effective. They have proven to be extremely effective. What are the drawbacks? Well, the drawbacks are if you have a Cook Islands trust, you can't be in control of that trust. You're going to have an offshore trustee in the Cook Islands be in control of the trust because that's how it works. If you're in control, then the judge can order you to bring the money back. So you can't be in control. Two, it's clearly the most expensive option. When you have a trust that's fully offshore, you have offshore trustees fees. And third, compliance. You're going to file more IRS compliance because IRS has a higher burden placed on foreign trusts, of which clearly a Cook Islands trust is. And so the cost, the control, and the compliance are drawbacks. If you need to use it, yes, you want to be there. But if you don't need to use it, this is causing you to go, well, do I really want to have that type of trust if I'm not really sure if I'm ever going to use it? So let's talk about the domestic option. These are newer. The first domestic statute was in 1998 in Alaska, and they attempted to mirror the foreign statutes. The problem is that the U.S. is not outside of the country. So the foundation of the foreign statute is statutory non-recognition of any other jurisdictions, court orders, judicial proceedings, judgments, etc. In the U.S., we can't do that. We have full faith and credit. We have the Constitution, which connects all the states and requires them to recognize each other. But nevertheless, 16 U.S. states have now said, we think this is a great idea. So Alaska, Colorado, Delaware, Hawaii, Mississippi, Missouri, Ohio, Nevada, all the way to Wyoming, even Tennessee and South Dakota. So the concept caught on because states and the people in those states recognize that protecting your assets is a very legitimate concern, particularly for high risk people like business owners and anyone in the medical space. So what are the advantages of a domestic trust? Well, the costs. Typically, they cost less because there are more providers domestically. There are more trust companies in more jurisdictions. Compliance. Well, it's not a foreign trust, so it has much less compliance. It still has to file a trust tax return, but it doesn't have the foreign trust compliance component. What are the disadvantages? Well, unfortunately, and this is really kind of the kiss of death, effectiveness. Because it's a domestic trust still in the United States, we have several examples of trusts that have completely failed. Even though they were set up timely and they were set up properly, they still failed. So unfortunately, they don't have the same track record as the foreign trusts because they're still in the United States, subject to the discretion and jurisdiction of the U.S. courts. And two, control. If you are going to try to use a domestic trust, you still have to be completely out of control. That's the only chance that you would have. So you still lose control. And unfortunately, the effectiveness really kills it for me. I don't use domestic only trusts. I just don't feel comfortable because there's no way to truly know what a U.S. judge is going to do. And what I have learned is that U.S. judges do what they want to do. They sometimes see a result that they want to achieve, and that's where they focus. So the domestic only option is for me not a valid option for my clients. The offshore option is a valid option in the right circumstance where there's truly a very, very real risk. But my question 20 years ago was, how would I get the advantages of the international trust, but keep it as simple as domestic trust, if not a little simpler? And the answer was the bridge trust. So this concept has been used for the past 20 years by me created by me and our law firm. And what it is it's an offshore level of protection, but with domestic simplicity. And I'm going to explain exactly how we do that. There's no IRS Form 3520 or 3520A, which is the foreign compliance component of that foreign trust. There's no FinCEN or Financial Accounting and Tax Compliance Act disclosures because there's no foreign accounts. There's no foreign trustee in an active role. There's no IRS filing requirements of any time because it's a domestic trust as it begins its life. Assets can remain in the United States, can remain with your current advisor, with your current bank. It is very simple. There's no requirement of having a foreign trustee can control those assets. And in fact, you can be your own trustee for the trust. And this is a huge component. And one of the reasons why I like the bridge trust so much is that you can stay in control of the trust. It's a tax neutral domestic grantor trust. That's what it is. It's very simple. However, if we ever have a real threat to the assets, so we put these trusts in place for our clients, hopefully when the waters are calm, when they don't have any real threats, no real risks other than the normal business risks that they have, but no actual lawsuits in place or investigations going on. If later some of those things happen, then we can cross that bridge and the bridge trust becomes a fully foreign asset protection trust with all of the protections that we discussed in the international option. So it creates the best of both worlds. So if we go back to our four-part test, is it effective? Yes, because it's an international trust. Do you have control? Yes, you get to stay in control of that all the way up to the point where we cross the bridge, which again is only going to happen if we actually need to use the protections of the trust. Costs, it's less expensive than the international option for sure, and definitely the maintenance is much less expensive. And compliance, there's no compliance. There's no foreign tax compliance. There's no Form 3520. There's not even a tax return because it's a domestic grantor trust with you as the grantor and the trustee. So let's put it all together. The Asset Management Limited Partnership is your holding company. So we put that in the center of the page. What's going to go into that are these LLCs, which we represent as these little houses. So that might be your rental house. And you might have a sailboat, which would go into a separate LLC. You might have an airplane that would go into a third LLC. We could add as many of these as we need, office buildings, etc. The bridge trust will connect to that Asset Management Limited Partnership. And if you've done your revocable living trust, that's still going to be effective. You're still going to use that. So the LLCs are owned by the Asset Management Limited Partnership. What else is owned by the limited partnership? Well, we've got your cash, your stocks, your bonds, your collectibles, your coins, your Bitcoin, your cryptocurrency. Any kind of financial or securitized asset can be moved and held directly by the Asset Management Limited Partnership. So now we have your LLCs and all your securitized assets directly in the Asset Management Limited Partnership. Who's in control of that? You are. You're the general partner. So you have direct control of all those assets so you can do business. Who owns it? The bridge trust. They're going to be the majority owner, that bridge trust, which again, you have control of. So one of two things is going to happen at this point. Either everything goes along fine and you die, at which point all of the assets of both the revocable living trust and the bridge trust are going to pass down and through the revocable living trust. That's going to distribute your assets, maximize your state tax exemptions, avoid probate, and smoothly pass your assets to your heirs in a protected way. The other option is you have a crisis. We have an event of duress. And in that case, the assets will move, they will cross the bridge fully to the bridge trust out of the limited partnership. And then that bridge trust can be taken literally offshore, completely out of the US jurisdictions altogether. So the message for this webinar, and I hope it was clear, is that there are extremely effective tools to protect your assets. The key is they need to be put in place when you're not in a crisis situation. If you put in place a structure that utilizes these tools now, and you have a crisis in 2 years, whether it's an employee lawsuit, whether it's a patient lawsuit, whether it's a car accident that your insurance has decided they're not going to cover or which exceeds your insurance, regardless of what it is, moving across the bridge, triggering the plan, taking the assets from a less protective place like a bank account in the United States to a more protected place like a bank account offshore is completely possible to do because the ownership of those assets is already been transferred. And um, the one question I get consistently is, Doug, how can we move those assets after a problem arises? Isn't that a fraudulent conveyance? Which is a term that I think most people are familiar with, which is the idea that if you convey an asset with an intent to delay, hinder, or defraud a creditor, then that conveyance can be voided. Well, the reason we can move assets after the fact is that the conveyance is getting the asset into the initial structure, which means into the LLC if it's a risky asset, or into the limited partnership if it's a safe asset or a securitized asset, all of which are held by the bridge trust. So the conveyance has occurred now, 2019, we set it up February, March 2019, and in 2022, we have a crisis, we have a real threat to the assets. The conveyance has already been done. So the fraudulent conveyance analysis looks back to that time. We can then move the assets physically from the less protective jurisdiction to the more protective jurisdiction without any issues. So that's a common question. I'm sure there's more questions. I wish that we had a live option to answer questions because I know a bunch of you have questions that would come up, but I'll answer a couple more that I know I get a lot. One, what is the cost of this? The cost of asset protection ranges anywhere from zero in the case where you already are protected to $35,000 and up. And it just depends on what you need. So what I encourage is people to do an analysis with me, and I can then say, okay, you happen to live in Texas. In Texas, your primary residence has an unlimited homestead exemption. And then your only other real asset besides the equity in your home is you have a qualified plan, an ERISA-based plan with the vast majority of the rest of your assets in it. Well, that's also protected. And so I can often deliver the good news that you're really completely protected without doing any further asset protection. And that's a huge relief if that's your case. Sometimes we just need to use the domestic types of tools, just some LLCs, a limited partnership, and that's enough because the equity levels in the assets are such that that's going to be a sufficient level of planning. Other times, using those in conjunction with the bridge trust is really the most appropriate because the assets are big enough. So it's a function of the level of risk that you carry personally and as a business owner, the level of assets that you have, and frankly, the level of tolerance that you have for risk. And we look at all three of those and we help our clients make a clear analysis and make a good decision about how to protect those assets. So I can be reached at this contact information on the screen. My website is lodmell.com. And there's also a lot of other information material I'd be happy to send you. If anyone would like to email me directly, you're welcome to. My email is just my name, Doug@lodmell.com, DOUG@lodmell.com. And of course, you're welcome to call our office at 800-231-7112 and say, hey, I saw the webinar for MedResults. I just would like to have an analysis for MedResults clients. We do not charge for that, so be happy to do that at no cost. And it takes about a half an hour. We go through your personal situation. We look at all those considerations and help you to understand what your options are. So I hope this has been really helpful for everyone. I tried to keep it as concise as possible so that we don't just run into all the details. There's lots of digging down, and I'm sure some people have those types of questions, and I'm happy to answer them if you email me after the fact. I think Jamie also mentioned you can chat those questions into the question box, and she's going to send them to me, and then we're going to answer them individually. So I'm happy to do that for anyone on the call or on the webinar. Otherwise, Jamie, I think we did it. And unless there's a question that you might have, I think we wrapped.
Sure. No, thank you so much for your time, Doug. And to everybody who's still on the line, as Doug mentioned, you can reach out to him directly using his contact information on the screen. Or if you feel comfortable and you want to email me, I can connect you directly to Doug. So either way, please feel free to reach out. We appreciate your attendance today. And once again, thank you for preparing this great presentation. I certainly learned a lot as well, Doug. And we look forward to having everybody at our next webinar presentation in 2 weeks. And have a great rest of your afternoon. Thank you again to everyone.